Okay, everybody. I hope everybody's having a good week. We'll do our lecture today on law of principal and agents, or law of agencies, if you will. And then we'll talk about some business organizations, which I know a lot of you have already talked about and had in other classes, but we'll talk about it in this class also. So if you have your notes there in front of you, of course, what we'll do, again, like we always do, we'll go through the lecture and then I'll go through a few of the test questions that we go through here, okay? So the law of agencies, if you get your handout here in front of you, the law of agencies, you'll have, if you go to law school, you'll have a course in agencies, and then you have the next semester, you usually have a course in partnership. Some law schools have agencies and partnerships together because the law of agencies and partnerships is so much alike. That's a test question, by the way. And so if when the test questions they ask about the agencies, partnership, the law of agency partnership is they're a whole lot alike. And like I say, some law schools even have agencies and partnerships in the same semester. So let's look at this, and then we'll do the agencies, and we'll go into some partnerships. All right, look at you see the terms here: principal, the person for whom the agent acts. The agent is the person who acts for the principal. In business transactions, the third person the agent deals with on behalf of the principal. So when you go to law school, if you go to law school and you take this course of agencies, you have the term principal and you have the term agent and third person, okay? And what you'll do is you'll kind of fill in, kind of go into these and fill out as you go what the duties are of the principal to the agent, and the principal to the third person, and the duties of the agent to the principal and to the third person, and the duty of the third person to the principal and the agent, okay? Here's the way it works. Suppose you're a real estate agent, okay? You would be who? You would be the agent. The principal would be the person who hires you to sell the house, okay? The third person is the person you're dealing with. So you have these relationships, and you would go kind of fill them in. We'll talk about them in this short lecture here. Okay, so again, just keep that in mind. Just, principal, agent, third, like a real estate agent, okay? Principal, agent, third person. What are the duties of, again, the principal to the agent and to the principal third person? The duties of the agent to the principal, agent to the third person, usually the third person to the principal and the agent, okay? Now, so you got those terms right there. Now let's look at classifications of the agents, okay? You have general agents and special agents. Have you ever heard the term power of attorney? If you have a special power of attorney, you can only do what you were empowered to do, such as I always tell people in the military, if they're going to give somebody the power of attorney, like to sell their house or car or whatever while they're overseas, then you wouldn't want to give that person a general power of attorney because that person can do anything you can do. If you give a general power of attorney to somebody, they have the authority to do anything you can do. If you give a special power of attorney to somebody, that would be like special power of attorney to sell the house or to sell the car, okay? And that's all they can do. They have the special power of attorney to do that. So a special power of attorney is what you would want to give somebody to do something specific for you if you're going to be out of town or overseas or whatever. If you give somebody the general power of attorney for you, that person can get into your bank account. They can sell more than the house. And by the way, things happen. You would never believe the things that happen when you give somebody a general power of attorney. They can do anything and everything that you can do. So general power of attorney or general agent and special agent. A general agent can do anything you can do. You empower them. You give them the power and authority to do whatever you can do. And the special agent, you can empower them to do something like on a house or something, okay? So those are those classifications of agents now. All right. Now let's look at relationships similar to agencies, okay? And we have the employer-employee, all right? Now let's get this in our minds now, okay? So we've talked about the principal-agent relationship, okay? Now we're going to talk about relationships similar to that but different. We're going to look at employer-employee relationships and employer-independent contractor relationships, and they're going to be different, okay? So let's look at first employer-employee. If the employer, if the person controls the manner, methods, means, time, and place of employment, there is an employer-employee relationship there, okay? The people that come into this law firm that are my paralegals and the secretaries, they are employees. They come in at a certain time. They come into my building. I pay for the utilities. I pay for everything here. I control the manner, methods, means, time, and place of employment. Okay, those people, they would be employees. Okay. Now, what if I call it? So, what if the copy machine breaks down, or something breaks down here at the office, and I call somebody to come in and fix the copy machine? Is that person an employee of mine? No. That person is an independent contractor. That person would be come into, if you have the, again, if you have hire the real estate agent to do something for you, that person is not an employee. That person would be an agent. Okay? You don't control the manner, methods, means, time, and place. If you come in and hire me to be your lawyer, I'm not your employee. I would be, if you give me the authority to bind you contractually, then I would be an agent / independent contractor. You don't control the manner, methods, means, time. I don't come to your place of business. Now, if I was general counsel of Boeing, then I would be the employee of Boeing. But I'm not, and I would be an independent contractor. Okay, so we have the employer-employee relationship. We have the independent contractor relationship. For instance, if I were to hire somebody to build a house for me, would that person be my employee? No, that person would be an independent contractor. They can use subcontractors and everything, but that person would be an independent. That's not an employee. That person does not. I don't control the manner, methods, means, time, and place of employment. They're independent contractors. Okay, so we know that, we got that in our minds now. Okay, and then you say, so what? All right. Well, so what is, go down to number 13 on your. If you look at your handout there, go down to number 13, if you will. And it talks about tort liability of the principal and the employer. So if you look at your outline, go down to Roman numeral 13 there, tort liability. And you'll see the term respondeat superior there. All right, let's go through this. If I have my law clerk, if I have Hannah Lynn, if I were to ask her to go serve a subpoena at Bridge Street. My office is downtown, but if I say to her, go serve a subpoena at Bridge Street, and on the way there, she runs a red light and kills somebody. That wouldn't happen, but I'm talking about if she's the employee, okay, if she runs the red light and hurts somebody or kills somebody, would she be liable if she actually did run the red light? We've already talked about negligent law, haven't we? Duty of care, breach duty of care, cause damage. So if she does that, would she be liable? Yes. Who else would be liable? I would be liable. If the tort or culpable act is committed within the line and scope of the employment, okay, then the employer would be liable on the theory of vicarious liability. Qui facet praelia facet per se ergo respondeat superior. Let the one who does to another respond. Respondeat superior. Okay, it's called vicarious liability. So if the tort or culpable act is committed within the line and scope of the employment, then the employer would be liable. I have a paralegal that works for me, Carmen, she lives in New Hope. Suppose I sent her to Bridge Street to serve the subpoena, but she goes and sees her daughter in New Hope before she goes and serves a subpoena. And when she's going over to New Hope to see her daughter, she has a wreck and hurt somebody. Would I be liable for that? The answer is no, because it was not within the line and scope of the employment. She was not, I said, take the subpoena to Bridge Street and serve the subpoena, but she decided to go to New Hope to see her daughter before she did that, so the tort was not committed within the line and scope of the employment. Therefore, I would not be liable. She'd still be liable, but I would not be liable because it was not within the line and scope of the employment. Now, if she were to have to take a detour and commit a tort or culpable act, have an accident, I would still be liable for that. Okay? So if you've got a Walmart 18-wheeler going down the interstate and it goes into your lane and hurts you, and causes you to wreck and hurts you real bad, would the truck driver be liable? Yes. Who else would be liable? Walmart would be liable because that was a Walmart truck and it would be within the line and scope of the employment. Therefore, Walmart would also be liable. So who's got the money? The truck driver or Walmart? If you're a lawyer, you're looking to get Walmart involved, and if that tort was committed within the line and scope of the employment, then Walmart would be liable on the theory of what? Respondeat superior. That's a test question now, okay? Respondeat superior. That's where the employer is responsible and liable for the tort or culpable act of the employee. All right. Now, what about if the copy machine breaks down and I call the person to come and fix the copy machine, and on the way to fix my copy machine, they have a wreck and hurt somebody? Am I liable for that? That's an independent contractor. Would I be liable for that? Answer: no. They're not an employee, are they? They're an independent contractor. They hire the person to build the house for me, and somebody, one of the construction people, has a wreck on the way to the job site. Would I be liable for that? No, because that person's independent contractor, not my employee. Only if it's my employee. Now, what about like when people they go to places and they make the people sign that they're an independent contractor? In other words, they are an employee, but they make them sign this piece of paper. This company makes you sign a piece of paper saying you're not an employee, you're an independent contractor. Well, if you commit a tort or culpable act, and they try to get out and say, well, no, you're on your own. You're not an employee because you signed this thing saying you're an independent contractor. Well, I always say this: if it looks like a duck, it quacks like a duck, it's a duck. Okay, if they make you sign something to say you're an independent contractor, where in fact you are an employee, then you go through what that document says that you signed, and were you in fact an employee or were you an independent contractor? So big corporations, a lot of times they'll try to get out of things by saying, well, no, this person wasn't an employee, independent contractors. Okay? So, now, okay, what about your real estate agent? What about an agent? The real estate agent is you've hired the real estate agent to show your house for you, to sell your house. They have a prospective buyer in the car with them. They have a wreck and that person gets hurt, and it's the agent's fault. Are you liable for that? You're the principal. Are you liable for that? Answer: no. The agent is not an employee. That agent, you wouldn't be liable for that. Okay. Now, an agent could be an employee slash agent. If you give an employee the authority to negotiate prices and to do what you could do, then that person can be an agent slash employee. So if you have a situation where that's the case, then they would be liable. You would be liable, okay, on the basis of vicarious liability. So again, if you have the employer-employee relationship and a tort or culpable act, we've talked about torts, is committed within the line and scope of employment, then the employer will be liable. Now, that does not apply to intentional torts, though. Remember we talked about intentional torts, negligent torts, and strict liability? That does not apply to intentional tort. If my employee goes out and shoots somebody, if I have an employee that does that, they go to Bridge Street to serve a subpoena and end up getting an argument with somebody and shoots them. That's an intentional tort. I'm not liable for that unless I know that the employee has a propensity for violence. If I know that, then they could get me for negligence on that, for negligently hiring this person. Okay, but I would not normally be liable for my employee doing an intentional tort. All right. So that's another thing interesting. If you have a company car and you drive the company car, you're not within the line scope of the employment, but you drive a company car and you're taking your family out to eat. You have a car wreck. It's your fault. Would the employer be liable? Those are good questions, aren't they? But the main thing for our test, for our situation, if you go to law school, you'll do a lot of cases on this, but it don't change. That's it. That's the law right there. And the big thing is whether or not it's within the line and scope of employment. So that gets your tort liability there. So let's get back now to our lecture here, okay? Now, creation of the principal-agent relationship. All right, got our, and how do you start the principal-agent relationship? Number one is by contract. If you hire me to sell your house for you, and I'm the real estate agent, and we have a contract, then we have a principal-agency relationship created by contract, okay? Next, an agency by estoppel. That's where a third person is led to believe that a person is an agent because an appearance of the principal-agent relationship exists. All right, here we go. There is no principal-agent relationship, but I lead, I'm the principal, whatever, and I lead the public to believe that you are my agent. Oh, suppose that I have Mark's car lot, okay? And you're my student, and I know you're a good student, and you come by the car lot, you come by and say hi, and you stay there a good bit, and I give you a card, got your name on it, says salesperson, whatever, you come there a lot. I know you're not an agent, not an employee. You know that. I don't pay you. You just come by and shoot the bull, but I give you a card, whatever. Right. So I go to lunch, 12 o'clock. Okay, you're there. You're not my employee. You're not my agent. Okay, you know that, and I know that. Okay, so a person comes into the car lot, and they say, "Hey, I like that Ford 150 pickup truck over there." Okay, and I've got it for sale for, let's say, $50,000. Okay, and you say to the person, "Here's my car. Would you like to take a test drive?" And the person says, "Yes, I'd love to take a test drive." Y'all take a test drive. You go in and get the key, come out, and take a test drive. The person says, "Well, I'd like, how much, I'll offer you $40,000 for it." And you say, "Okay, deal." And you go in the office, you get out the paperwork, sign it all up. Person gives you, remember the contract, person gives you the money, you give the person the key. All right. They're gone. They leave. I come back from lunch and I say, "Hey, where's the Ford 150? Where's the Ford 150? And you say to me, "Well, I sold it." And I say, "Well, you did. What'd you sell it for?" And you say, "I sold it $40,000. And I said, "Man, I had 45,000 in it. I mean, you shouldn't have done that. You didn't have the authority to do that." And I say, "Get on the phone, call the person up, and tell them bring the car on back over here." We'd set it to them for 48. And tell them bring it on back over here. So you call that person up, and the person don't bring the Ford back. The person calls their lawyer, and the lawyer says, "Don't take the Ford back. You got a Ford. You got it." Okay. Now, here we go. Did I create or allow a situation to exist to where that third person could reasonably believe that you had the authority to sell that vehicle? And I think the answer is yes on that. Okay? And so I will be stopped. There's an agency by estoppel created. I'll be stopped from denying an agency relationship where I allowed a situation to exist that led the third person to believe that there was, in fact, an agency relationship. So the third person says, "I'm not bringing it back." And they got them a Ford 150 for $40,000 because I allowed that situation to exist. All right. Now let's say this. Let's suppose that I go to lunch. You're not my agent, but you sell that Ford 150 for $50,000. I come back from lunch and I say, "Where's the Ford 150? You say, I sold it. I said, well, you didn't have the authority to sell it. And you say, well, I did. I sold it for $50,000, which is what you was asking for it. And I say, well, you did a good job. And I ratify it. That's a test question. It's called ratification. When the principal ratifies the act of the agent, then you created the agency relationship there by ratification. Okay, I ratify that act. If a person comes in here and not a member of the firm, but says, I signed up this contract, this automobile accident for you, Mark. No, I'm not a member of your firm, but I signed this case up for you. I know you do those kind of cases. I'm going to ratify that contract. Okay, I'm going to ratify it. It's called ratification. The person didn't have the authority to do it, but they did it, and I ratify it. All right, so I'll do that. Okay, so you can kind of see that how that goes there. You got 8 by contract, by estoppel, and then number 3 is by ratification. Okay, ratification is proven of an unauthorized act. All right, so you can have an agency by estoppel created where I lead the public to believe that this situation exists, and it don't, but the third party can reasonably rely upon that. All right. Now another way is where somebody does something that does not have the authority, and I ratify that act. Again, you sell the car for more than it's worth or what I'm asking for. I'm going to ratify the contract. Okay. All right. But if I lead the situation, let a situation exist that leads the third person to believe there was authority where there was not, then an agency by estoppel. So contract, estoppel, and ratification is the way you can create an agency relationship. Okay? All right, now let's look at the obligations of the agent to the principal. Remember, the obligations of the principal, the agent, principal, third person, agent to the principal, agent to the third person, and the third person, the principal, the agent. All right, but the biggest one is what are the obligations of the agent to the principal? And this is a test question, okay? The agent owes the principal a duty, a fiduciary duty. A fiduciary duty. A fiduciary duty is the punctilio of honor and good faith, the highest degree of honor and good faith. A fiduciary duty is that. Okay? I owe my clients a fiduciary duty. I owe my clients the highest degree of honor and good faith. What if I have 20 cases set for trial Monday morning, and I have one of the people paying a whole lot of money and the other 19 not paying as much money, and I go to the DA and I say, look, I don't really care about 19 of these people. The one of them, I want a deal on this one. I got to have this one dismissed. I mean, I got to have a deal. Okay? Now, did good for the one, didn't I? But I breached a fiduciary duty to the 19. All right. I always tell young lawyers this, that if you're going to be a trial lawyer, and I've represented, people ask me all the time, especially young law students, what's it like I represented Governor Hunt when he was indicted. What's it like representing a sitting governor of the state of Alabama? Not one that's out of office, one's in office. What's it like doing that? And I say, in all sincerity, no difference between representing the governor and a homeless person. No different. And if there is a difference, then don't be a trial lawyer. Be something else. You can be corporate trial, tax law, whatever. But don't be a trial lawyer. If there is a difference to you in your heart and in your soul and within you, if there's a difference, then just be something else, because there is no difference. You owe, if you take a case of pro bono, and I've taken many cases on pro bono, all right, in death penalty cases, many of them pro bono, okay? And when you do that, you owe that person the same fiduciary duty, the highest degree of honor and good faith, the punctilio of honor and good faith, as you do the person that pays you a big, big legal fee. You owe that same fiduciary duty, okay? What if I am your real estate agent and you have your house for sale for $600,000, okay? And I show your house to somebody and that person says, I want to offer $600,000 for that house now. And I say to the person, well, wait a minute. Before you make that offer, I've got a house down the street here, down the road. But it's a whole lot better house. It's a whole lot better. It's just a better house, okay? It's $750,000. I know it's more, but I want you to look at that before you make this offer. And I take this person down there and they buy that house. But they were ready to make an offer on your house. Did I breach a fiduciary duty to you? Yes, I did. Because one of the things about a fiduciary duty is I owe you a duty to communicate that offer to you. I had a full offer for you, and I was told no. Now, if you probably never find out about that, like the lawyers doing stuff or whatever. But if you found out about it, you could sue me and make me buy the house for $600,000 because I breached a fiduciary duty to you. I owe you the highest degree of honor and good faith. I have to communicate that to you, that offer to you. I had a full offer for that, and I didn't tell you about it. What about a lawyer that gets an offer on an accident case and don't tell that to the client, and then you go to court and you don't get anything? Suppose you got $1 million offer, and the lawyer thinks, man, I believe I can get $2 million or $5 million, and you don't tell your client that the company offered, the insurance company offered $1 million, and you go to court and you get nothing. Now, if the client never finds out about that, so be it. You're all right at lawyer, but if the client finds out about it, which I hope that they would, then they'll sue you for the $1 million, and your insurance, you got to pay it, or your insurance malpractice guy, whoever, they got to pay it, okay? You owe that client a duty to communicate that to that client. If you represent somebody and they offer, in a criminal case, and they offer them 5 years and you turn it down and then you go to prison and they get 30, and you go to court and you get 30 years. What have I told you 100 times in this class? Do you know what a jury's going to do? Can any lawyer tell you what a jury's going to do? If they do tell you, I know what a jury's going to do, don't hire that lawyer. They don't know what a jury's going to do. I mean, like I said, I've told you so many times. I've been practicing law a long time, and I don't know what a jury's going to do, okay? I got a good track record, but I don't know what a jury's going to do in every case, all right? So keep that in mind. And that word, that fiduciary duty, when you get an offer on anything, agent, whatever, you get an offer, you have an obligation to communicate that. Do you have a duty to do accurate accounting? You have a duty of loyalty, it's a reasonable skill, accurate accounting, communication. You see those terms, fiduciary duty. Okay, just keep in mind, it's not hard. It's just, it's just do right. Don't act, if you're representing somebody, don't act in your interest, act in their interest. I always say public servants, act in the, and I've been on the Asset Advisory Council and Board for International Food and Agricultural Development, got a president's appointment with that in the USA appointment. You're not acting for yourself, you're in a public position, you're acting for the taxpayers, you owe the taxpayers a fiduciary duty, okay? If you're going to have a public position, I've been on the airport authority for over 18 years. I don't owe myself a fiduciary duty, I owe the public a fiduciary duty because I've been appointed onto that board, and anytime you're on a board or you're in a public position, you owe the taxpayers a fiduciary duty, the highest degree of honor and good faith, okay? All right, let's keep going here. Obligation of the principal to the agent is to pay them, okay? If I sell that house for you, give me, pay me for that, okay? All right, termination of the principal agent's relationship, pretty common sense. Fulfillment of purpose, I sold the house. Mutual agreement, we both agreed I can't sell the house, right? Revocation of authority, I'm your real estate agent, you call me up and you say, I don't want you to sell this house, you're fired, okay? Renunciation by the agent, that's where the agent says, I can't sell the house, I can't, and you get out of it that way. By operation of law, DEA comes and confiscates the house because of whatever. Subsequent destruction of subject matter, the house burns down. All right, all that's common sense. All right, contract liability of the agent. All right, you see the term disclosed principal, partially disclosed principal, and undisclosed principal. Okay, now let's look at this. A disclosed principal is one where you're my agent and you're out there for me, and you tell everybody, I'm the agent for Mark McDaniel. I'm his agent. Okay? That's a disclosed principal. A partially disclosed principal is where I tell you, I want you to do this act for me as my agent, but I don't want anybody to know that you're acting for me. You can tell them you're an agent. You're operating for somebody, but you can't tell them it's me. Now, like at the airport authority, we have people come in all the time looking to locate in Huntsville, Alabama, and they want to be close to the airport. We got a lot of land out there, and so they want to be close to the airport. The company. Now, they don't mind us knowing that they're for somebody. They just don't want us to know who, because if they're going to relocate a business, they don't want the employees of that business in that other state know that they're even looking. So they can say, look, we're looking to do this here, but we're not going to tell you who we're for. This is a search team or whatever. They're out trying to find the best place to relocate. So they don't want us to know. And by the way, we have to sign non-disclosure agreements that we're not even going to talk about the fact that they were even here, and we're not even supposed to know who they were there for. But we know we're dealing with an agent. We just don't know who for. We can find, if they come in a corporate jet, and they fly from here to here, we're at the airport. We can find out where they came from, whatever. But anyway, we do sign non-disclosure agreements, so we couldn't talk about it. Okay, but we know we're dealing with an agent. Now that's a partially disclosed principle. Okay. Now, where you can get in trouble as an agent is where you're dealing with, where you have the undisclosed principal. Now, here's where that goes. All right, I tell you that I want you to go buy this company for me. And they're asking, let's just say $20 million. And I say to you, if I go to buy this company, they're gonna ask me full price, $20 million, okay? But if I tell them I'm not interested in it, and you go in and offer them $15 million, and I'll give you $3 million, okay? And if you can get this deal for 15, I'll give you $3 million. Now, if they know you're working for somebody, they're going to assume you're working with me. So you're on your own. You've got to tell them this is you. Now, if we do it that way, what you need to do is go get you a lawyer, and you need to have $18 million put in an escrow account, in your lawyer's escrow account, okay? So that if you do this, you got the $15 million for the business that you're going to buy, and you get the $3 million that I promised you, okay? Because you're on your own. You be signing the contract. Everything you're signing on your own, because if they know you're doing it for me, they're not going to sell it for $15 million. They're going to think, he'll pay 20. It's like sometimes people say, I wouldn't sell that if you got estate situations where or somebody, whatever. I wouldn't sell that to Mark McDaniel for nothing in the world. I wouldn't sell that, nothing. I would never. Well, I'm going to get somebody as undisclosed. I'll be an undisclosed principal. I'm going to hire somebody to go out and buy that thing and then turn around and sell it to me. Well, you say, well, that's unethical. No, it's not. They sold the land. They got their money. They just didn't want to sell it to me because I wouldn't sell it to him for nothing because he blah, blah, blah. Well, okay. Well, then I go out and I do it. Now, by the way, when I do that, if I ever hire you to do that for me, you have whatever I'm wanting to buy, you make sure that money, you go to your lawyer and get that money put in the escrow account, and then whatever money I promise you put in that escrow account too, so that when you buy it, because you're signing out there. See, the other way you're signing, your name, for Mark McDaniel, agent for Mark McDaniel. You're signing, they know you're dealing with an agent. But when you have an undisclosed principal, the third person don't know that. So you're on your own, okay? And so just do it the way I'm telling you there. So you got the disclosed principal, partially disclosed principal, and undisclosed principal. Now let's look at test question 2 here. Let's see what we got here. On this part right here, let's see here what we got. Okay, bear with me here. Okay, a person who agrees to perform services under the direction and control of another person is A, an independent contractor, B, a licensee, C, an employee. Answer, C, employee. When a principal's actions create the appearance of authority which does not exist, an agency relationship A arises by ratification, B arises by estoppel. What's the answer? I don't have to go further than B, do I? By estoppel, okay? All right, let's see. Chris, a general contractor, has entered into an agreement with Sabre to build a swimming pool. Chris is A, an employee, B, a gratuitous agent, C, an independent contractor. Answer, C, independent contractor. Okay? All right, let's see. Let me keep going here. I'm see number 16, 18. Okay. Which of the following duties does an agent owe the principal? A, the duty of performance. B, duty of reimbursement. D, the duty of indemnification. D, duty of compensation. And number 18, answer there is what? Would be A. Okay? Agent owe the principal. 18. Which of the following duties does an agent owe the principal? Performance, reimbursement, indemnification. Okay? Yeah, we got that. All right, so let's see the next one here. Do another one real quick. Let's see here. That'll be what I got. Same thing, I said 12. 12 there. When a principal accepts the benefits of a contract entered into by his agent, even though the contract was not authorized by the principal, and agency A does not exist, B arises by agreement, C arises by ratification. Answer, C, ratification. Okay? All right. Now, we got, I think that's most of the questions on that lecture. There might be one or two more. All right, let's go into the business organizations. And we'll do this and get a few questions on that. So let's look at the business organizations. Again, most of you have had something or already had courses, so you understand a lot of this. Sole proprietorship. We know what a sole proprietorship is. That's Mark McDaniel Coffee Shop. All right, I'm not a partnership, I'm not a corporation. Mark McDaniel, private investigator. I'm not any kind of business. Mark McDaniel sole proprietorship. And what's the benefit of that? It's the cheapest way to start a business. It's just me. Okay? I'm in control. I don't have shareholders. I don't have partners. It's Mark McDaniel. Okay? Sole proprietorship. All right, what's the downside of that? That I've got total liability on me. We'll find in corporation law, it meant the corporation shields the shareholders from debts and obligations to the corporation. In partnerships, the partners are jointly and several liable, so you could have the other partners, liable with you. Okay? When you're the sole proprietor, you got all the liability. You got all the authority. You're the boss, but you also get all the liability with that. Okay? You don't have any shield there. But it is a cheap way to start. It's the cheapest way to start the business. Okay? All right. Let's look at partnership. When I talk to you again, you're going to hear a lot of this about the agencies and the agency law here. So let's look at this with partnerships. Now, partnership is an association of two or more people that go in business for a profit. Now, I don't like partnerships. I'd rather be an LLC, but I'd rather be a corporation. And you'll see as we go along why. The number one cause of divorce is money. Well, what was the definition I just told you about a partnership? The association of two or more people go into business for a profit. That's money. So you have your best friend in the world, and when it comes to money, sometimes you have a problem. Okay, you just by the way, in divorce, number one, money; number two, sex; number three is in-laws. Cause for divorce, but it's not domestic relations, but so I won't go any further than that. But so you got that, you got the partnership. So I don't really like partnerships. We're going to see more of that in just a minute. I always say if you have a partnership, it needs to be about a 500-page document. Try to cover everything in there, but you'll still leave something out. But try to have everything covered in that partnership agreement. All right, let's look at forming the partnership. Express agreement, partnership in a partnership by what? Estoppel. So you can have one way you can do it is by we agree to it. We put something in writing. We have an express agreement where we're a partnership. McDaniel and Jones partnership. Okay? Then you're a partnership. All right, you have the agreement, express agreement. No, next is by estoppel. That sounds familiar, don't it? Remember the agency? All right, let's go through that. Your grandfather dies, or your father or grandfather dies, and all your life, for the last 30 years, you knew your grandfather was a partner in this firm, and after you have to go through the funeral and you probate the will. Let's say you're the executor of the estate, so it's your job to you're authorized manager to distribute the estate of the testate, person name with the will. That's your title. That's your definition of executor. So you go to the place of business that your grandfather was the partner, and this person, you say, I need to talk to you about my grandfather's partnership interest. And the person says, your grandfather wasn't a partner. And you say, well, he always said he was. And the person says, no, he was an employee. He was not a partner. He was an employee. And you say, well, he never said that. He just, and the person says to you, you go find a document, some kind of written agreement that said there was a partnership between me and your grandfather, and bring it to me. And you're not going to find it because it was not there. There was no agreement. Okay? Sorry. I don't know what he told you, but it wasn't that way. He was an employee. Now suppose he did start off as an employee, but suppose sometime during the business that the other man made him a partner. Didn't ever put anything in writing, made him a partner. So you just give up. No, you don't. You go home, first of all, you can start going through all the files. And you look in the files and you see a card there. You see a check where it has your grandfather's name and this other person as partners. You go through old newspaper and through advertisements that have been run and see that there have been advertisements run as your grandfather and this person's a partner. You see a sign. Now, by the way, when you went over there after your grandfather died, that sign wasn't there. But you see a sign that was 10 years ago in an advertisement that said your grandfather had to sign your grandfather's name and the other person's partners. Were they acting as a partnership? Were they holding themselves out to the public as a partnership? And the answer is yes, it's a partnership by estoppel. Now, by the way, suppose that situation exists and your grandfather, let's say your grandfather's still alive, and the person makes him a partner for 10 years and then decides, calls him in one day and says, I decided I don't want you to be a partner anymore. You're the employee. You're an employee now. Back to the employee. Can they do that? No, because a partnership by estoppel was created. Okay? And once it's created, you've got a partnership. Okay, it's like in Alabama, up a couple of years ago, you had common law marriages. You didn't have to go through a ceremony. Some states still have it. Alabama had it up until about 2 years ago. If you cohabited as husband and wife, held yourself out as public as husband and wife, and it was mutually exclusive of all others, you married in Alabama. Now all people say, well, how long did it take? Well, you could be common law married in a one day, or you could live with somebody for 30 years and not have those agreements, and you'd never be common law married. But if up until 2 years, by the way, anything happened up until 2 years ago, you could be common law married. Okay, you can't do it now, but if you did it, if you cohabited, if you met all the requirements of common law marriage up until that point, you're married in Alabama now, and you have to go through a divorce just like if you went through the biggest ceremony in the world, back to partnership by estoppel now. All right. So if you create this situation exists, and your grandfather was a partner, and you want his interest, you're gonna get it. Okay. You're not gonna give up like a lot of people would. You're going to go through them files, and you're going to go do some searching, and you're going to find out, because your grandfather was right. He was a partner, okay? And if your grandfather's alive and he come in and told you that, hey, I just got fired. I thought I was a partner. He told me no, he can't fire a partner. You can dissolve the partnership, give him his half, but you can't fire him, okay? So no. Just remember this kind of. You learn this. I hope you learn this. You can't have it when people start treating you a certain way. Then that's the way it is. You're a partner, okay? Partnership by estoppel. Remember, agency by estoppel, partnership by estoppel. Same rules there, okay? All right, now let's look at this right here. Operation of the partnership, rights of the partners, duties of the partners. Powers of the partners, liabilities of the partners. Well, let's go through that, okay? First of all, the liability is unlimited liability. Remember sole proprietorship, unlimited liability. You get sued, you say unlimited liability, and get your house, cars, everything. There's nothing shielding you. Same way with the partnership, unlimited liability, okay? So that just simply means that if you've got 5 people in a partnership, and an employee commits a tort or culpable act, and they get sued, and the judgment for $10 million, and you got $1 million worth of insurance, $1 million in the partnership, $8 million is owing. Okay, who's going to have to pay that? The partners. There's nothing shielding them that you lose your house, your car, your bank accounts, everything. Now, by the way, you got 5 members in the partnership. You're jointly and severally liable. That means you're all liable, but you're also severally liable. That means the person can sue one of you. Now, you're going to bring the others in, but what if you're the one with the money and the 4 others don't have money? If you're going to go in a partnership with somebody, make sure they got as much money as you got, okay? Because in that situation, you got $8 million owing on this judgment, and you got the $8 million, and you want the others to help you out, and they don't have money, anything. They've taken their money in partnership, and they've had a good time with you. You've saved yours. You got $8 million. Well, you're going to have to pay it. Now, you can bring them in, but they ain't got it. So you can't say, well, to the creditor, you can't say, well, I'm just going to pay my 1/5. No, you're going to pay it all. Okay? That's partnership. I don't like partnerships because there is nothing shielding. You're subject to unlimited liability. You can lose your house, your bank accounts, your children's education money. You can lose all that in a partnership. You're jointly and severally liable. All 5 of you liable, but you're also severally liable because the one that's got the money can be the one. By the way, the person can sue just one person. If you got 5 people, they can sue number one. Number one's going to bring in 2, 3, 4, and 5. But again, if they don't have the money, you ain't going to get anything. There's nothing to be there to cover you, as the person, as the partner with the money. Okay, so keep that in mind. Now you have unlimited power in there. You have each partner. Okay, we've been in business. Okay, and we've been in business for 10 years, and we got a good business. It's been going really, really good. Okay. We'll just say 2 people in a company. All right, you come in, and there is a brand new Mercedes S500, out in the parking lot, brand new. Okay, about a $140,000 car sitting out there in the parking lot. You walk in and there's this young lady sitting at the front desk. You hadn't seen her before. You come in the office, good morning, Mark. I say, good morning. And you say, have a good weekend? Yeah, had a real good, had a good weekend. Yeah, had a good weekend. Yeah. I saw, is that your new Mercedes out there? No. No, it's not. It's a nice looking car, yeah. I saw that, who's that new employee out there? That's our new executive vice president for marketing. And you say, well, she looked mighty young. Yeah, she is. 21 years old. Where'd she go to college? She didn't. She didn't go to college. But well, how much we're paying her? Paying her $125,000 a year. That Mercedes is her. It's her company car. She needs a fine, fancy car. She's executive vice president for marketing. And you say to me, I don't like that. And I say, I don't care. And you say, well, if we're going to do that, I'm going to get out of the business. I'm going to sell my interest. And I'm going to say, you can't sell your interest. You can't make me that's another thing about partnership. You can't make me be in partnership with somebody I don't want to be in. All you can do is divorce me. It's called dissolution of partnership. You can dissolve the partnership, file a legal action, dissolve the partnership, take your half, I'll take my half, after paying all the debts and everything, split up everything, and we're gone. We dissolve that partnership. Or, now what if I'm the rainmaker? What if I'm the one bringing in all the business? Now, a little lesson in business here. Usually the rainmaker's not the best business person. They can get the business, but they're not, a lot of times, the best business person. The best business person is usually the person that keeps up with everything. It just goes into details and keeps up with everything. I'm very fortunate. I got people around me that do that for me. Okay, I don't worry about that. Like I tell everybody, I wake up for the last 48 years. Every morning I wake up, I'm unemployed. I've never worked for anybody. I work for clients. And if I'm a good enough lawyer, I keep getting hired. And if I'm not, I won't. But 48 years, it's worked. I've been blessed. I'm still in business, but I've been unemployed every day I wake up. I've been unemployed. So, you go in there and you say, well, old Mark, he bringing the business. We've got a good business here. We've been making a lot of money. I think I'll go along with our new executive vice president for marketing and see if I can work with her. Or you can divorce me. You can file a dissolution. Okay. You see why I don't like partnerships? I mean, I don't like that. I don't like it to where you don't have divorce that. Works like that. Okay. So that's that. That's the partnership. And I think you can see why I don't like that. Let's go into limited partnerships real quick. A limited partnership is if you draw a line here and you put A up here and X, Y, Z down here. Let's say you started with $1 million. Okay. X puts in 100,000, Y 400,000, Z 500,000. You start off with $1 million. A up here don't put anything in. A would be the general partner. In the limited partnership, A up here is like a general partner. A has unlimited liability. All X, Y, and Z can lose in the event of a big lawsuit or some kind of problem, financial problem. All they can lose is their investment. All X, Y, and Z. X can lose 100,000, Y 400, Z 500,000. Okay, that's all they can lose. So let's say you got the $10 million lawsuit, $1 million worth of insurance. You got $1 million in the company, $8 million owing, A up here don't have anything, and so you say, okay, well, they're not going to get the $8 million because all the limited partners just liable for their investment in the business, unless X, Y, or Z participates in the management and control of the business. If there's that line there. Now, if I'm the lawyer trying to collect that $8 million, if I'm one that sued your limited partnership, and I'm representing the person, I'm going to try to get X, Y, or Z's notes above that line so that I can get their house and their car. I can get them, if I can get them above that line for their limited partnership, but above that line and make them general. Now, how do you do that? If I can show they participated in the management control of the limited partnership in any way, ever so slightly, then I got them. They lose their status as limited partner and become a general partner. Okay? Such as A calling them up and say, look, what do you think about doing this deal? And if they give an opinion, they have participated in the management control. What do you think I should do about this? They give an opinion, they've participated in management control of the limited partnership. So if you're going to be a limited partner, be a limited partner. Don't be a general partner. Be a limited partner. Okay? So that's some of the best legal advice I can give you. You stay below that line because the law says it's so easy. Once you do anything where you participate in the management control, you lose your status as a limited partner and become a general partner. And we know if in a general partnership we just got through talking about, you have unlimited liability. Okay? Now, let's go into corporation law, corporate law. Okay? You're going to see this is what I want you to do. If you're going to go in business, I want you to be an LLC or you want you to be a corporation. The best definition I've heard of a corporation is one John Marshall gave an opinion many, many, many years ago. He said a corporation is an artificial person, invisible, intangible, existing only in contemplation of law, being the mere creature of law, possesses only those characteristics which its articles of incorporation confer upon it, the two main being individuality and immortality. What John Marshall said was if you're going to be a corporation, you will be a separate legal entity, but you have to act like a corporation. If it's Mark McDaniel LLC, I better act like Mark McDaniel LLC. I better have a shareholder. I better have a board of directors. I better have meetings at least once a year, shareholders meetings, and then board of directors. I better have minutes of those meetings. Well, you're just a small corporation. It don't matter if you get sued. If you get that, here we go. You get that $10 million lawsuit. You got that $10 million judgment against you for whatever, okay? $1 million insurance, $1 million in the corporation, $8 million owing. Okay, you want to be shielded. The corporation shields the shareholders from the debts and obligations of the corporation. Now, creditors are going to try to pierce the corporate veil, and come and get the shareholders. I promise you, if I am a person and I've got a $10 million judgment against a corporation, even a small corporation, but if I got that $10 million judgment against them, then and I got $1 million from insurance and $1 million from the company, I'm going to start looking for ways to pierce that corporate veil and get to the shareholders, X, Y, and Z, let's say. Okay? Now, how do I do that? I do that if you don't act like a corporation. If you start a corporation, your accountant can tell you, okay, you're in good shape for taxes, you start a corporation. That's fine, but for liability purposes, if you don't act like a corporation and you get sued, that corporate shield is not going to shield you from the debts and obligations of the corporation. And that's what you want to start. One of the main reasons you want to start your corporation is to shield you from the debts and obligations of the corporation. So if you got that $8 million owing, we know the partnership's got to pay it, sole proprietorship's got to pay it. Limited partnership, you're going to have to pay it if you participate, if you're a limited partner in the management control of a limited partnership. But in a corporation, the corporation is going to shield you. You're not going to have to pay that $8 million because that corporation is going to shield you from that if you acted like a corporation. If you did not act like a corporation, then they're going to pierce the corporate veil and you're going to be liable. You're going to set it all aside and you're going to be like a general partnership. Okay? Now, keep that in your mind and let's listen to this now, okay? What are the duties of the shareholders of a corporation, the board of directors of a corporation, and the officers of the corporation? Keep this in your mind over here about piercing the corporate veil. You got me? All right. The duties, okay, what can shareholders do? Shareholders have the power to elect the board of directors. That's their power. If you've got one share of Disney stock, you got one vote. If you got 1,000,000 shares, you got 1,000,000 votes. You got 5 million shares, you got 5 million votes. That's what you got. You're a shareholder. I don't care if you got 100% of the shares. That don't give you the authority to. I mean, unless you put yourself on the board, what you can do is elect the board. You have one vote to elect the board of directors. Now, if the corporation decides to dissolve, then you'd have a vote on that too. But let's suppose, you're in the corporation. What power do you have as a shareholder? You have the power to elect the board of directors. Okay? That's your power. All right? Now, what are the powers of the board of directors? You plan the business strategy of the corporation, set the dividend policy of the corporation, and you hire and fire corporate officers. That's where the power is in the business, is the board of directors. Okay? I've been on several boards. The most important thing you do as a board member is you hire and fire the chief executive. Okay? CEO. Everybody else is hired by the CEO, but your job is to hire the CEO. It's pretty important, isn't it? Okay? By the way, if you're ever invited to be on the board, usually get invited to be on the board by the CEO. Well, you hire and fire that guy or that lady, okay, that person, and so you're getting invited to be on this big board, and it's nice. You get these nice meetings, and you get to go to these things, And what if? Who do you, as a board member, if you're on the board of directors, who do you owe a fiduciary duty to? Remember that fiduciary duty, that punctilio of honor, good faith, high school of honor, good faith. You get invited to be on that board by the CEO. But who do you owe a fiduciary duty to? The shareholders. You owe fiduciary duty to that custodian that's got money in stocks that they don't even, it's in their retirement plan. Some stock company, whatever, some investment company, they've got the retirement, they're managing the retirement account for this company, and they bought the shares of the corporation that I'm on the board. Who do I owe that fiduciary duty to? The CEO that put me on there, this big board? No. To that school teacher, to that secretary, to that construction worker, to that person out there that's working that don't even know who I am. I don't owe the CEO a fiduciary. I can hire and fire that person. That's my job. If they're not doing a good job, if they're doing something wrong and it's not beneficial to the shareholders, then it's my job to vote to fire that person, even though they put me on the board. I don't owe that CEO a fiduciary duty. I owe the shareholder fiduciary duty. If you're ever on a board of directors, you keep that in mind. That's who you owe that fiduciary duty to. You owe that fiduciary duty to not the powerful and rich. You owe it to the working people out there that's got the stocks in that corporation. If you're on a board of directors, okay. All right. So that's very important. So what are the powers of the officers? The power of the officers do the day-to-day dealings, okay? All right, now, let's go through this. The corporation's been sued. It's a $10 million judgment, okay? $1 million insurance paid, $1 million to the corporation. So that's been paid to the plaintiffs, to the people who got hurt in the car wreck. And let's say the corporation had an employee commit a tort or crumple act, $10 million judgment against the corporation. Okay? $8 million is owing. Now, we know who's got to pay that in the sole proprietorship. We know who's going to pay that in the general partnership. You know, and we know who's going to pay it in limited partnership if that limited partner participates in management control of the business, limited partnership. But in a corporation, the $8 million is owed by the corporation unless the shareholder didn't act like a corporation. So 2 or 3 months after this case is over with, probably like 3 months, if I'm the lawyer, you're going to get a subpoena from me. Now, you're just a shareholder, but you're the biggest shareholder. And I have you come in my office. And you come in my office, and I'm sorry that we had this litigation, but I've just got a few questions to ask you now. Sew some things up, and I say to you, state your name, and you state your name. And suppose you're listening. You suppose you're the person with let's suppose there's 1,000 shares in the corporation. You own 900 of them. And I say, okay, you had 900 shares of the corporation. And you say yes. I got a court reporter there taking everything down. And I say, now you, as a person with 900 shares of the corporation, you made yourself the president, correct? You answer that. What would you say? If you say yes, and I say, as a person with 900 shares of the corporation, you set the dividend policy. You had 900 shares. You had most shares. You say yes. I don't have to go much further, and I wouldn't go much further. I would say thank you for coming. They have the court reporter type of that transcript. I would file a motion, set the corporation aside, and declare you a partner instead of a corporation, because you didn't act like a corporation. I would also ask you, did you have any shareholders meetings? No. You have any board of directors meetings? No. You have any share certificates? Share certificates shows the ownership of the corporation. No. Well, you wouldn't act like a corporation, was you? So that judge is going to grant my motion, and I have pierced the corporate veil. I've gone through the corporation, and I've got you. You didn't act like a corporation. Let's do it again. You come in my office, and you have a corporate kit, which has your bylaws in it, and has your minutes of your meetings, and has your share certificate. I want to know right then I'm not going to get that $8 million. I'm not going to get the $8 million. And I start asking you questions. By the way, if you had a lawyer call me and say, look, Mark, they did everything right. If you want to see all the minutes and everything, I got them. They acted like a corporation. They had their shareholders meetings. The shareholders elected the board. They adjourned their meeting. An hour later, they had a board of directors meeting, and the board of directors planned the business strategy, declared dividends. That's the reason there wasn't more than $1 million because we declared dividends, and we hired and fired corporate officers and set their salaries. And that's the reason, there wasn't that much in the corporation, but our shareholders are multimillionaires. But you're not going to get any of that, Mark, because they acted like a corporation. I'm not going to get that $8 million because you acted like a corporation. And by the way, I've been able to pierce more times than not pierce the corporate veil and get to the shareholders because they did not act like a corporation. They started the corporation for tax purposes, but they didn't act like a corporation. So if you're going to be a corporation, I don't care how small the corporation is, act like a corporation. So if you ever get sued and there's ever anything, you've got that shield. It's shielding you from the debts and obligations of the corporation. And I won't get the $8 million. I'll never get it. I'll get $2 million. I get insurance money, and I'll get whatever's in the corporation. And if there's nothing in the corporation, I won't get anything. I'll just get the insurance money. You may have $20 million out of that corporation. I'm not going to get a dime of it. And there may be, you may have it where everything was rented in the corporation, and there's nothing, corporation owned anything, but you got $20, $30 million. I'm not going to get any of it because I'm not going to be able to pierce the corporate veil because the corporation is liable. You're not liable. You acted like a corporation. Okay? Now, let's get a few test questions off this, and then we'll get this done here. Let's see here. Corporation number 22 here. Let's see here. 34 here. Let's see here. Okay, at the first meeting after a corporation is formed, the incorporators, A, elect the board of directors. That's going to be your answer, okay? Okay. The directors and officers of a corporation are blank of the corporation and its shareholders. A, fiduciaries. That's it. B, partners. C, limited partners. C, preferred shareholder. Answer is fiduciaries, okay? All right, let's see here. Okay, generally as to shareholders, personal liability for a corporation's business debts are A, the shareholder has unlimited liability. B, the shareholder may be liable to the extent of his personal assets. C, shareholder's liability is limited to the amount of his investment. D, the shareholder's liability is limited to the amount of the present market value. And the answer is going to be C. You're not just that. You're not going to be liable for the debts and obligations of the corporation. Let's see here now. 22. Okay, potential personal liability is limited in all but which of the following business forms? A limited partner, limited liability corporate companies. B, corporations. C, general partnerships. D, limited liability partnerships. Answer is C, general partnerships. There is unlimited liability for a general partner. We've already talked about that now, okay? Unlimited liability, okay? All right. If a general partner negligently injures someone in the scope of the general partnership's business, who may be liable? A, the partner who caused the injuries. B, the partnership. C, all the partnerships in the partnership. D, all of the above. Answer, D, all of the above. Okay. When you're a partnership member, everybody's liable, okay? Okay. On occasions, courts will impose partnership liability when the partners did not intend to form a partnership. This concept is called A, special partnership, B, partnership by estoppel. I don't have to go further than B, do it. Partnership by estoppel, okay? Okay, next, I'm just about overall, I'll have a few on left. This form of business is run for profit and made up of two or more owners. A, joint venture. B, corporation. C, sole proprietorship. D, partnership. Answer, D. So it's just two more people going to business for profit, okay? And we got enough, we got a pretty good bit of those questions right there. All right, hope that you know, not just for our test purposes, but for your future, there's some things in here, you just kind of remember this stuff, and it will, I think, save you a whole lot of money in your lifetime somewhere down the road there. But it's always an honor to spend some time with you, and hope you enjoy a little bit of the lecture today, and thank you so much for listening.